On July 9th of 1868, the state of South Carolina joined 27 other states by voting to ratify the 14th Amendment to the United States Constitution, the first section of which reads, in full, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The first fundamental provision included in this section is the Citizenship Clause, which established the legal concept of birthright citizenship. This clause specifically codified the premise, introduced in the Civil Rights Act of 1866, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. The Supreme Court further ruled in Elk v. Wilkins, 1884, that the main object of the opening sentence of the 14th Amendment was to settle the question that all persons born or naturalized in the United States and owing no allegiance to any alien power should be citizens of the United States and of the state in which they reside. Despite the unambiguous clarity of its language, an executive order was issued on January 20th of 2025, falsely asserting that the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States, and that it has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. In addition to being factually and historically untrue, Executive Order 14160 is itself inherently unconstitutional. It claims that its provisions have been ordered by the authority vested in its signer as the President by the Constitution, despite the fact that the Constitution does not vest that authority in the President. The primary intention of Executive Order 14160 is to interpret the 14th Amendment, and the interpretation of law, up to and including the United States Constitution itself, is an authority vested solely in the judicial branch, the Supreme Court, and the courts that operate under it, that cannot be legally exercised by any order issued by the executive branch.